So these are some interesting preliminary provisions I came across in the California Family Code. As you may be aware, California's over 155,000 individual statutes are contained in 29 codes, starting with business and professions and ending with welfare and institutions. The ninth alphabetically is called the Family Code. Now, all 29 of the California codes have general or preliminary provisions. And some of these provisions have to do with reading and interpreting that code's specific sections. I was recently reviewing the introductory provisions contained in the California Family Code, and a few of them caught my attention. And I've added a little bit of commentary to after the citation of each section. So in section 3 of the Family Code, it says that a provision of this code, if it is the same in substance as a provision of a uniform act, it is to be construed to effectuate the general purpose to make uniform the law in those states which enact that provision. So my comment is that uniform acts are an important tool in drafting statutes, both nationally and internationally. The idea behind a uniform act is that all legislative bodies that adopt them use the same language so that the provisions, of course, apply uniformly across all of those jurisdictions. As a result of this, those interpreting the provisions of a uniform act can and should do so in a manner that ensures uniformity across all jurisdictions that have adopted the Uniform Act, and any court decisions that have been made in other jurisdictions having that Uniform Act can often be adopted by your own state court. Section 4 of the Family Code says that new law means either of the following: the act that enacted this code, or the act that makes a change in this code, whether effectuated by amendment, addition, or repeal of a provision of this code. It also defines old law to mean the applicable law in effect before the operative date of the new law, and that operative date means the operative date of the new law. And it says in subdivision B that this section governs the application of the new law except to the extent otherwise provided. My comment here is it's interesting because it's one of the few instances where the terms old and new laws are used in California statutes. In addition to the Family Code, I found them in the Probate Code, the Code of Civil Procedure, and the Financial Code in just a few limited instances. Now, there are other ways to say the same thing, but these codes have used the approach of distinguishing between prior statutory provisions and newer ones. Also, the definition of operative date, I don't know if you caught it, but it's not particularly helpful as it refers to itself. Operative date means operative date. An effective date, of course, is generally defined as when the law is on the books, which is usually January 1, except for those bills that take effect immediately upon the governor's signature. And the operative date is when the law applies. It's most often as a default January 1, but can be delayed to a specified operative date. Section 5 of the Family Code says that division, part, chapter, article, and section headings do not in any manner affect the scope, meaning, or intent of the code. My comment here is that although this statement is contained in a number of the California codes, the courts of this state have sometimes ignored that and actually have used these headings in interpreting ambiguous statutes, again, despite the contrary stated purpose by the legislature. As a result, legislators do need to pay close attention anytime they're creating these types of headings, because in fact, they may be used to affect the scope, meaning, or intent of a particular code. In section 6 of the Family Code, it says that unless the provision or context otherwise requires, that the general provisions and rules of construction in this part govern the construction of this code. My comment here is that as I've previously mentioned, all the 29 codes have similar general provisions, and some of them have limited rules of statutory construction. However, despite the intent and desire of the legislative branch in enacting these types of statutes providing guidance, it is, of course, the judicial branch that's charged with interpreting the laws of the state. And as a result, the judiciary may follow these types of statutory provisions, or they may ignore them, depending on how the judiciary decides that it's going to interpret the law. Section 8 provides definitions of division, meaning a division of the code, part, meaning a part of the division in which the term occurs, chapter, meaning a chapter of the division or part, as the case may be, article, which means an article of the chapter, section, which means a section of the code, subdivision, which means a subdivision of the section, paragraph, which means a paragraph of the subdivision, and then subparagraph, which means a subparagraph of the paragraph in which the term occurs. My comment here is I like this particular section of the family code because it's one of the few instances where the different levels of hierarchy of California codes are defined. This code, again, the family code, is where a body of statutes of related topics are found. We have similar instances, health and safety, penal code, evidence code, etc. Under this code will come these other parts and all the way down to the individual statutes, which of course we call a section of the code. And then you get into the items within the code itself. The definitions contained here are the hierarchy of a code. And then it follows that the definitions are the hierarchy of a code section or an individual statute. Then there's section 12 of the family code. It says that the term shall is mandatory and may is permissive. The terms shall not and may not are prohibitory. My comment here is that this is a standard provision in California codes and the way in which our state statutes have long been drafted. California law uses the term shall as opposed to must, which occurs in many other jurisdictions. We also use the term may rather than can. The attorneys in the Office of Legislative Counsel, they attempt to draft using action words, again, in the affirmative voice, and they do so in a consistent manner. And so it's important that our state laws follow these rules, and these are set forth in the 29 codes. Finally, there's section 13 of the family code. It says that if a provision or clause of this code or its application to any person or circumstance is held invalid, the invalidity does not affect other provisions or application of this code, which can be given effect without the invalid provision or application. The comment here is that this is standard severability language. A number of codes and even individual sections or statutes contained severability clauses. There's a split in view among bill drafters. Some believe that it's important to have to ensure that the judicial branch will keep intact any provisions that are not invalid when otherwise striking down unlawful provisions. Other commentators understand that the judiciary generally automatically takes that approach even without a severability clause in the statute or in the code.